The U.S. government just announced a major policy change that affects millions of green card holders across America, and if you're a lawful permanent resident, this could impact your ability to travel, renew your green card, or even maintain your status. Stay with me because what I'm about to share could save you from serious immigration consequences. Welcome back to the channel. If you're new here, I break down complex immigration updates into simple, actionable information that you can actually use. Today, we're diving deep into a critical USCIS rule change for 2025 that every green card holder needs to understand. Before we get started, make sure you hit that subscribe button and turn on notifications so you don't miss any important immigration updates that could affect you or your loved ones. Let me start by addressing what's actually changing. USCIS has implemented new guidelines regarding how green card holders must maintain their permanent resident status, particularly focusing on physical presence requirements and documentation standards. This isn't just another bureaucratic shuffle. These changes carry real consequences for people who travel frequently, work abroad, or have family obligations outside the United States. The first major change involves the documentation requirements for proving continuous residence. Under the new rule, USCIS is taking a much stricter approach to evaluating whether green card holders have truly maintained their residence in the United States. Previously, the guidelines were somewhat flexible, and immigration officers had more discretion in determining whether someone had abandoned their permanent resident status. Now, there are more concrete benchmarks and documentation requirements that you need to be aware of. Let's talk about what this means in practical terms. If you're a green card holder who has been outside the United States for extended periods, you now need to provide more substantial evidence that you maintain ties to America during your absence. This evidence includes things like U.S. tax returns, proof of property ownership or lease agreements, U.S. bank accounts with regular activity, employment records, children enrolled in U.S. schools, and utility bills in your name. The key word here is substantial. USCIS wants to see a pattern of life centered in the United States, not just a mailing address or a bank account that sits dormant. The second significant change relates to the one-year absence rule. Most green card holders know that if you stay outside the United States for more than 1 year without obtaining a re-entry permit, you risk losing your permanent resident status. What's different now is how USCIS examines trips that are close to but under 1 year. Even if you've been outside the country for 10 or 11 months, officers will now scrutinize whether you've established a pattern of spending more time abroad than in the United States. They're looking at the totality of your travel patterns over several years, not just individual trips in isolation. This brings us to an important concept that many green card holders misunderstand. Maintaining permanent residence isn't just about avoiding trips longer than 1 year. It's about demonstrating through your actions that the United States is your primary home. Under the new guidelines, USCIS is explicitly stating that frequent extended trips, even if each one is under a year, can be evidence of abandoned residence. For example, if you're spending 8 months abroad and 4 months in the U.S. every year, that pattern could raise serious red flags during green card renewal or when applying for citizenship. The third major update concerns re-entry permits. A re-entry permit allows green card holders to stay outside the United States for up to 2 years without losing their status. Under the new rule, USCIS is being more stringent about who qualifies for re-entry permits and what reasons are considered valid. You now need to provide detailed documentation explaining why you need to be outside the United States for an extended period. Acceptable reasons typically include employment with a U.S. company abroad, caring for an ill family member, or pursuing education that's not available in the United States. Vague explanations or plans that suggest you're simply living abroad while holding onto your green card will likely result in denials. Another critical aspect of this update involves the green card renewal process, specifically Form I-90. When you file to renew your green card, USCIS now requires more detailed information about your travel history and physical presence in the United States. You'll need to provide a complete list of all trips outside the country, including exact dates and purposes. Any gaps or inconsistencies in your travel history can lead to requests for evidence or even trigger an investigation into whether you've abandoned your permanent resident status. This means you should be keeping meticulous records of every international trip, including boarding passes, passport stamps, and any documentation related to your purpose of travel. The new rule also impacts conditional permanent residents. Those are individuals who receive their green cards through marriage and are still in the 2-year conditional period. The requirements for removing conditions using Form I-751 now include enhanced documentation standards. You need to provide more evidence of a bona fide marriage and joint life in the United States. USCIS is looking for things like joint lease or mortgage agreements, joint bank account statements, joint tax returns, insurance policies listing both spouses, photographs together at different times and places, and affidavits from people who know you as a couple. The documentation needs to span the entire conditional residence period, not just be from when you're preparing to file. For those who work remotely or have business interests abroad, the new guidelines present particular challenges. USCIS recognizes that modern work arrangements allow people to work from anywhere, but they're clear that green card holders cannot use remote work as a way to live abroad while maintaining U.S. permanent residence. If you're working remotely for a U.S. company but spending most of your time in another country, this could be viewed as abandoning your residence. The solution in these cases is to ensure you're spending the majority of your time physically present in the United States and can document that presence. Let me address some common questions and misconceptions. First, does this mean you can't travel at all? Absolutely not. Green card holders have always been free to travel internationally. What matters is the duration and frequency of your trips and whether you maintain clear ties to the United States. Short trips for vacation, business, or family visits are not a problem. The issues arise when you're spending more time abroad than in the U.S. or when your actions suggest you've made another country your primary home. Second, what if you have a legitimate reason for extended absence? This is where documentation becomes crucial. If you need to care for a sick parent, work on a special project abroad, or fulfill a temporary business assignment, make sure you're documenting everything. Keep records of why you need to be abroad, evidence that it's temporary, and proof that you're maintaining your U.S. ties throughout the absence. Consider applying for a re-entry permit before leaving if you know you'll be gone for more than 6 months. Third, what happens if you've already been outside the United States for a long time? If you're currently abroad and realize you might be in violation of these guidelines, you need to consult with an immigration attorney before returning. Depending on your circumstances, you might need to apply for a returning resident visa at a U.S. consulate, known as an SB-1 visa. This process requires you to prove that your extended absence was due to circumstances beyond your control and that you always intended to return to the United States. The enforcement of these new guidelines is already underway. Customs and Border Protection officers at ports of entry have been trained on the updated standards, and they're asking more detailed questions when green card holders return from extended trips abroad. Don't be surprised if you're taken aside for secondary inspection and asked to provide evidence of your U.S. residence. Having documentation readily available, such as proof of employment, recent utility bills, or evidence of property ownership, can make this process much smoother. Looking ahead, these changes signal a broader trend in immigration enforcement. USCIS and CBP are investing in technology that allows them to track travel patterns more effectively. They can see your complete travel history and identify patterns that might suggest residence abandonment. This makes it more important than ever to be proactive about maintaining your status and keeping thorough records. If you're concerned about how these changes might affect you, here's what you should do right now. First, review your travel history for the past 5 years and calculate how much time you've spent outside the United States. Second, gather documentation that proves your ties to America, including tax returns, property records, employment verification, and bank statements. Third, if you're planning any extended trips abroad, consider whether you need a re-entry permit and apply for one if necessary. Fourth, keep detailed records going forward of all international travel and the reasons for each trip. And fifth, if you have any concerns about whether you've maintained your residence, or if you're facing questions from USCIS, consult with a qualified immigration attorney who can review your specific situation. Remember that immigration law is complex, and these new guidelines interact with many other aspects of maintaining permanent residence and eventually qualifying for citizenship. When you apply for naturalization, USCIS will review your entire history as a green card holder, including your physical presence and travel patterns. Any issues with maintaining residence can affect your citizenship application years down the line. So there you have it, a comprehensive breakdown of the new USCIS rule for green card holders in 2025. This is a significant change that requires attention and action from millions of permanent residents across the country. The key takeaway is this: your green card represents permission to live permanently in the United States, and you need to actually live here to maintain that privilege. Don't treat your permanent resident status as a backup option while you live somewhere else. If you found this video helpful, please give it a thumbs up and share it with any green card holders you know who might benefit from this information. Immigration rules affect real people and real families, and spreading accurate information can help people avoid serious consequences. Drop a comment below if you have questions or if there are other immigration topics you'd like me to cover. I read every comment and use your feedback to create content that actually helps you. Don't forget to subscribe and hit that notification bell so you never miss an important immigration update. I post new videos every week covering everything from visa processes to citizenship requirements to policy changes that affect immigrants in America. Thank you so much for watching, and I'll see you in the next video. Stay informed, stay compliant, and take care.